there's great complaints about plain statement rules that purport to avoid sensitive issues, so the Ashwander rule. Those complaints include the idea that courts rule on constitutionality without actually analyzing the constitutional arguments. So we must avoid serious constitutional questions, so we'll construe the statute narrowly. But I take it these equitable constructions are much more like a pure avoidance canon, where in the course of making the decision, they definitively say, if applied in this way, the law would be unconstitutional. Is that right?
David? 2 points. Permoli did not hold the First Amendment didn't apply to the states.
Speak up.
Permoli, this is just a factual thing that always bothers me. Permoli, it does not say that the First Amendment does not apply against the states, because no one had to say that. Everyone can read Congress. That's the religious, the New Orleans case. That's the Supreme Court case. It involved the federal statute that governed Louisiana before the statehood and whether it was still applicable. It's just an important thing, because some constitutional issues aren't even issues, and Congress is not the state. That's just a small point. The bigger point is the use of the word carve and fiction repeatedly throughout to describe what's going on in the 18th and 19th centuries. And when I was reading, I was like, okay, so the judges are butchers and liars. They carve and they make things up. There's two. One of them is about a historical error, but the other is it's unpersuasive to the tender-hearted judges even today, who like to think of themselves as submissive to law rather than lying and taking statutes and chopping off parts.
So really interesting paper. I think there's a strategy here of conflating a lot of related doctrines and practices. And I'm not always convinced that they are conflatable, if that's a word. But in any case, I'd like to push you to think harder about that. So for example, some of the things that you cite, like the quotation from Marshall on your slide, really seem to me just to be about judicial review and not about an exemption. Marshall saying the courts can overturn a statute that's inconsistent with the Constitution. Then there's the equity of the statute canon, like Blackstone's Surgeon, where again, it's really not about an exemption, it's about saying we're going to read this as inapplicable here because if it were applicable, it would violate higher law. Then you get closer to, I think, exemptions with constitutional avoidance and as-appealed challenges. But again, these are all different doctrines, and I'd like to see you be maybe a little bit more careful about recognizing that there are distinct doctrines that can or cannot speak to the question of religious exemptions. And then finally, given that you've got 5 cases from the 19th century and 2 go one way and 2 go the other and the other one's punts, there's a possibility that this is an area where historical methodology just might not be very helpful. And you give many, many reasons, your slide for all the reasons why these cases don't arise, why the specific issue that you're interested in, religious exemptions, just didn't come up.
Rick, I think that there was a range of how judges approach that question. And so sometimes it did sound more like constitutional avoidance to me. And sometimes maybe it felt more like the rule of lenity. And this goes a little bit towards what Jeremy is saying as well. I think that this equitable interpretation tradition actually gave rise to lots of different things that we now put in discrete, different doctrinal boxes or canons. And I don't think that those boxes existed around the founding period. And so we're sort of projecting our modern boxes now. But I think that a lot of that was pretty conflated around the founding period. So I think it's a good question. I think I would be oversimplifying if I thought that there was sort of necessarily one approach. And so to David, I hear what you're saying, that the fact that judges were relying on a fiction of legislative intent, especially if you consider yourself more of a textualist now, it maybe is jarring or troubling. I just think that this is something that John Manning has written about. He wrote about how that sort of tradition didn't fit well within our new constitutional tradition of separation of powers. And so one argument one might make as far as why that reliance on the fiction of legislative intent fell away was in part because our courts here didn't need to rely on that fiction as they sort of embraced more fully the fact that they were just engaging in constitutional adjudication. That's one possible explanation. I guess one other thing that I want to respond, Jeremy, about the Blackstone surgeon example. So, because I think this is interesting. It kind of goes to what do we mean when we talk about an exemption? And so if I'm thinking of an exemption as just saying that text that plainly could apply to a given circumstance is being interpreted more narrowly, deliberately by the judiciary, then I think that there's a lot of similarities between modern exemptions and what is happening with equitable interpretation. I think what Blackstone is talking about is absolutely an exemption. He talks about how, the law says whoever drew blood in the streets should be punished with the utmost severity in his hypothetical law. There's nothing ambiguous about that. It says the word whoever, that's everybody. And then Blackstone says, but of course, we wouldn't punish a surgeon who opened the vein of a person who fell in the street. That's not construction. There's not something ambiguous about the word whoever that we're interpreting. He's just saying, clearly that circumstance can't be one that should really fall within the plain language of the statute. And so, again, I'm ambivalent about what buzzwords or language or labels courts were using to do that. But to me, what is interesting is when they refuse to interpret laws as broadly as they could have been in order to avoid conflicts with reason or natural rights principles or constitutional principles. And I think it's at least plausible that free exercise falls within that context of the types of things that would have been a conflict like that they were trying to avoid with broad, generally applicable language.
So I was just wondering if maybe you could offer a deeper exploration of some of the exemptions cases. I mean, you talk about Reynolds, which I think, is sort of the case. But then I note that, there was no discussion of the Prince versus Massachusetts case. You've got, I think maybe 2 or 3 Jewish Sabbath cases that came before Sherbert. And then there's this whole area that I've actually been researching. Well, before I'll say that, then I think you have sort of the strange sort of mixing or strange defining of what is religion in the conscientious objector cases, which offer an interesting look at how we deal with exemptions. And then we've got this bigger area that I've written in, which is faith healing exemptions as they exist now. But some of that state law cases, there are state law cases that go back to the early 1900s on that. And then you've got a case in the mid 1900s on it. And those cases came along before the faith healing phenomena happened in the 70s, where now almost every state has a statutory exemption on their books for faith healing. So I just wonder if there's more of a story here to tell with regards to at least the U.S. Supreme Court jurisprudence. I always find it interesting that the Jewish cases were unsuccessful. So much so that in Sherbert itself, the court had to assure everyone that we are not pro-Seventh-day Adventists. It's just that we think there are some distinctions to be made, but they're garbage distinctions, right? I think I just think there is some how do we compare Prince, which said, no, your kid can't work, with Yoder. Of course, Yoder surrounds a larger body of cases dealing with religious education that go back to Myers and Pierce. So I just wonder if there's more of a conversation there to give us some understanding. And I'll just say at the end, I'm suspicious of Smith because it dealt with Native American religiosity, right? And so I just wonder, again, if you're looking at Sherbert versus the Jewish Sabbath cases, if you look at some different cases, I just wonder if there's I don't know. I don't know if there's because your story is a lot more than just these cases, but I do wonder if a deeper look at some of the jurisprudence would be helpful for the reader. But great paper. I really like it. I'm going to use it for my next one.
Thank you.
Stephanie, I also really liked the paper. I thought it was really interesting. I have a couple suggestions and then a question. Suggestion number one is that it would be helpful, I think, at least for me and maybe other readers, to hear more from you about some of the anxieties that the founding generation had about equitable interpretation. So maybe some discussion of the Chancellor's Foot problem, or maybe Chancellor's Foot problem, or Iredell's opinion in Calder against Bull as against Chase in sort of natural law reasoning by the courts. Just to touch on that issue, I think that might be useful. The second was on this question about the courts having alternatives to declaring unconstitutional statutes void. A nice case for your purposes, I think, although it's not a First Amendment case, would be Hayburn's case. So Hayburn's case involved the Invalid Pensioners Act, and there were two circuits that passed on it. One, on which Wilson sat, declares the statute void because it's going to turn the judges, it's going to basically set up a situation in which the judges' determinations are reviewable by the Secretary of War. But the other circuit, on which Jay sat, did something different. It basically engaged in, I think, equitable interpretation and decided that really they weren't asking to play the role of judges, but play an alternative role as some kind of commissioner. So they reinterpreted the language of the statute, in effect, equitably to avoid the constitutional problem. I think that would be a nice illustration for your purposes, perhaps. The question has to do with how everything you describe here relates to Article 3 and where the federal courts get the power to do this. And there are two questions, I guess, there that I wondered about. One is whether you're reading a power to engage in equitable interpretation into the phrase the judicial power. Is that how you're thinking of it? But then the second, maybe more plausible line is, and I was surprised you didn't address this, is what you make, given your project, of the jurisdictional grant to the federal courts to adjudicate all cases in law and equity arising under the Constitution or laws of the United States. Is that a source, on your view, for the kind of equitable powers that are being utilized here? You quote Wilson a couple of times, and I think that is Wilson's view, that is the textual basis for judicial review generally, but also the kinds of things that he says that you quote about law and equity being blended and both available to federal judges in our constitutional system. And I wasn't clear what your view was on that question and wondered, what you have to say about it.
Stephanie, I may misunderstand. I'm trying to maybe channel Philip Hamburger, what he might say. He might say, well, you found some new way of doing, finding possible exemptions, but there are really no more cases you found. And so how does this advance an objection to me at all? Indeed, you might say we've expanded the universe of ways judges could actually have found exemptions, but there, at least, and there are many other areas you found them, but none in the religion context. And so I'm not sure how much I think of that kind of argument to begin with, but in some sense, has one strengthened that argument because of the kind of other areas you found it and no areas here? That's just a perplexity I have about your paper.
John, thank you for those suggestions. I know the case you're talking about, and I think I hadn't thought of it in that light, so I appreciate that. As far as where I think that this power comes from, that is not necessarily a claim that I think I'm not sure that I have a position on it yet, in part because this article is more just focused on some of the descriptive historical claims that Smith was relying on, and some scholars have made that exemptions by the judiciary at the founding period, it would have been an anomaly. As Bradley says, it was a post-World War II invention. And so I'm just more trying to analyze is that descriptively accurate as a historical matter? I haven't really engaged as much with the theoretical questions of Article 3, but you're asking me that question is an important one and one that I will think more about, so I appreciate that. As far as John/Philip Hamburger over here, my friend in the corner, because I think it's a fair question. Part of what I feel like Hamburger and Bradley, and to some extent Justice Scalia, are saying is we don't have a ton of examples, and it would have been a sea change in the law, a really big deal, a new thing to have religious exemptions. And so if they would have been allowed in the religious context in this new and unique way, we would expect an awful lot of evidence to justify that there's any sort of historical or originalist basis for that. And so I take issue with that claim for a couple reasons. I actually think that, if we think about all the reasons why we contextualize the historical evidence we have, that they're overlooking some of the ways in which the current historical evidence is important. But I also think that a broader sort of claim that I'm making is that if judicially created exemptions aren't anomalous, if the judiciary is engaging in that sort of practice for a host of individual rights, then I sort of want to know from Philip Hamburger, why would that ability of the judiciary to protect rights in that way be uniquely unavailable in the religious context, when the judiciary is able to exercise that function to protect higher law norms across all sorts of other rights?
There are almost always accommodations that are granted by statute to some extent. If that's true, then the fact that the statute specifies the extent to which the accommodation is granted means, combined with your theory, there's nothing left for the judge to do, and therefore we're not going to see the sorts of claims that John would expect. So if it's true that the statute is specifying the degree to which there's an accommodation, and this is the way you get accommodations is through equitable interpretation, then it's perfectly logical that we wouldn't see the sorts of equitable interpretations that you're talking about very frequently, because the statutes are doing the accommodating work. Second point is, I wonder about the extent to which you're arguing about the historical origins of exemptions as opposed to the historical origins of religious exemptions. I can imagine somebody taking your paper and saying, here is the font of my secular conscience right. I can also imagine somebody replying in your shoes, say, I don't want to attribute this to you, but somebody who's trying to defend religious accommodations saying, well, yes, but the First Amendment prioritizes religion over non-religion. And my response to that is, that's a preferred paradigms thing from the 1940s. Like, you can't do that move if you're trying to do 19th century history. And so you need to show me, if you're going to do that sort of move, that there's actually a preferred paradigms, preferred freedoms paradigm in the 19th century, or you need to show me that there's actually a right to an accommodation of the sort you're getting into, and the equitable interpretation doesn't really help us there because it's just a circular thing. You have the right to the extent that you actually you have the right to be accommodated in so far as the statute's construed not to apply to you, only insofar as you actually have the free exercise right to begin with. That's the very issue that we're debating. So I just wonder about this sort of preferred paradigms model being superimposed on what you're saying in a way that's going to lead to just very anachronistic use of your argument.
So, thank you for this paper. I enjoyed it. I mean, you're responding to Justice Scalia's claim that a series of judicially recognized exemptions would be a constitutional anomaly by basically saying, well, courts have always construed statutes to exempt matters within their scope for various reasons or in various cases. I think there are two ways to understand Justice Scalia's argument that makes your response somewhat beside the point. The first is just one that I think John hinted at in his comments, and that's that it might be that a strong commitment to judicial constraint would make us depart from the original meaning in some cases. If the original meaning is, I think, as you suggested, is if the original meaning would give judges too much discretion. And that may actually, account for Justice Scalia's concern in these cases. But the other, I think, would be to say that whatever we can say about judicially crafted exemptions as a general matter, that there might actually be something distinctively problematic about exemptions for religious practice. And I think the best version of that argument, which Justice Scalia doesn't develop in Smith, is that in doing that, judges are inevitably going to end up preferring some religious claims to others, right? The claim of the Air Force cadet who doesn't want to wear a yarmulke will be treated differently than the claim of the Rastafarian who's told to cut off his dreads. And that's not just a pragmatic argument against exemptions. I think it's a claim that an approach that judges would end up preferring some religious claims to others actually would violate the Establishment Clause. And it would have violated even on some of the more narrow understandings in the clause, like Justice Rehnquist's understanding of the Establishment Clause to prohibit preferring some religions over others. And so I guess my question is, how does your account respond to that defense of Smith?
So I thought the paper was interesting. It was very informative for me, and I thought it was persuasive up to a point with a reservation that so this is my reservation. I'm not quite sure what to make of a claim that, this old practice of equitable interpretation of statutes is kind of a predecessor of, or almost the same thing as applied invalidity or free exercise exemptions. If the people were just thinking about what law is in a totally different way at one time than they're thinking about what law is today. So I would say today, just sort of the background most people assume is basically a positivist sort of view of law. Law is something enacted or, laid down by some identifiable authority. And I think that was apparent in some of John's comments on on your paper when you, he said, for example, in knowing what to make of these old cases, equitable interpretation of statute cases, they were either cases in which the judges were sincere and they were saying, we think we can help the legislature do better what it was trying to do by interpreting it in this way, or they were judicial power grabs. It was either the legislature that made the law and the court was really trying to follow that, or the judges themselves were making law. But if they were not operating in a basically positivist framework, if they were, it would be very difficult, and I certainly could never give a brief, or I could probably not give an adequate account at all of what the non-positivist framework, exactly what it consists of. But just to keep it really simple, if you think of it as something more like the law is not made by that person or this person, it's kind of there. And, and all these different things that we appeal to are evidence of what the law is and so forth, then neither of those would be the alternative. You think of an equitable interpretation of the statute as something like, this is just one thing we do when we try to figure out what the law is, So then, if you say, are you creating an exception to it? And so forth? Say, no, we're just, putting this material together in a way to figure out what the law is. Now, then the hard thing, I think, for your thesis, if something like that is true, the hard thing for your thesis would be, I just think, how do you transfer that to a different time or a different world in which people just aren't thinking of it that way? They're thinking more the way John was describing it, or the way Justice Scalia probably, in a positivist way is thinking about it. And that's the reservation. I just don't know, whether, if we ignore that, then I think you make a pretty good case that this is sort of the same kind of thing. But I have this sense that that isn't the way they were thinking about it, and so I just sort of point out that reservation.
One comment that I think applies globally to all three of those excellent comments just deals with what claim it is that I'm advancing in this article. So let me say what claims I'm not advancing. I'm not purporting to advance a claim about all the ways in which religious exemptions are normatively desirable, which goes to your excellent point, Peter, about why we might be concerned about judicial restraint, for example, in the religious exemption context. I'm not advancing all of the claims about why religious exemptions might be doctrinally appropriate for Establishment Clause purposes. And Jed, I'm not also advancing a claim about what the content of a religious exercise protection would have looked like. Like, would it have entitled you to an exemption at the founding period? Because I agree that's a separate question. And I need to say more explicitly in my article, I'm not taking on that question. I think Michael McConnell has done a really excellent job taking on that question separately, and I don't know that I could improve upon that. I am more modestly focused on some of the assumptions on which Justice Scalia and other scholars have relied that are descriptive historical claims. The idea that the judiciary simply didn't have power to craft exemptions at the founding period, something that Bradley claims that I think is just wrong. And the idea that if judges were crafting exemptions from generally applicable laws, that would have been an anomaly, something that Scalia is saying. I think that that's wrong. Or the idea that there's something really super special and owing of deferential about a broad, generally applicable law, and that we sort of owe homage to that. I don't understand why Justice Scalia feels so fondly of generally applicable laws, but early founding period judges didn't seem to always share that fondness. And so I think I need to make more clear in the article just the modesty of some of those descriptive historical claims that I'm engaging with, and your comments sort of helped me realize that. A question that I do have for you is, should I just take the things about equity being an ancestor of as-applied challenges out of the piece? I'm open to the idea that maybe I should do that. Maybe it's a separate piece, because I don't think that those descriptive historical claims really rise or fall on what equity ultimately evolved to become. I think it's interesting, which is why I put it in there. I think whether or not I agree with how it has evolved and how we translate that as a positivist matter now, it was sort of fascinating for me to research that a little bit, but I'm open to more feedback on that. And as far as the question of if the legislature is granting accommodations, and so that means subjectively we think the legislature didn't want to grant any other accommodations, or to Steve, your point about, is this just a power grab if we're not really looking at what the legislature intended? There are some interesting cases, and John Manning talks about the fact that the legislative intent rhetoric judges were relying on was not in any way an actual subjective inquiry of what the legislature really subjectively intended. It was more rhetoric as a placeholder to suggest that the legislature surely could not have intended to violate constitutional principles, for example, and therefore we are going to interpret the statute in this way. And so when you think of that legislative intent fiction in that more objective sense, then I think what the legislature is actually doing on the ground, or what accommodations have actually been granted, is less important to the inquiry, and it also looks less like a power grab if it's really, I think, just judges asking, ultimately, was the legislature drafting a statute that in this application complied with the Constitution or complied with other sorts of fundamental principles?
So a couple of points. So I take it like part of the argument here is, well, we didn't see a lot of cases with exemptions from the early period, and why is that? Does that count against the possibility that the Constitution creates these exemptions or allows for these exemptions, creates these exemptions, let's put it that way. And I just, you say, well, there were few statutes and they came about in sort of homogeneous places. So that would suggest there was very little sort of need for the exemptions. And then there were a few judicial opinions. So there might have been exemptions, but we just don't know about them. And then there's these equitable exemptions, so they might have been doing the work, so we never even get to that. And I find all that, informative and helpful. I just sort of wonder whether the next step would be, it's the kind of thing that I used to try to do when I was earlier in my career, is actually to look at a particular state. They don't actually have that many statutes. Most of the statutes are money bills and things like that. And to actually look at the statutes and sort of figure out whether or not, that this should have created a problem. I actually think it's people would have different reactions to it, but if one could show that, that there's not at all surprising, that might be more persuasive than or better evidence than saying there's few statutes and they're from homogeneous states.
Do you mean just looking at all the statutes of a state at the time to show how limited it was?
Connecticut, from 17, whatever the date you think it would be, let's say 1776 to to 1820. Now, once you pulled them out, you might say, oh, this is way too much. But I wouldn't at all be surprised if once you exclude the money stuff, that there's not that much at all.
That's a great point.
And then two other sort of quick points. You talk about the whoever drew blood example, and I can't let that pass. So you're absolutely right. The whoever part is categorical. It's pretty, and the interesting part about that is the drew blood portion of it. So for us at least, I think there's a meaning of drawing blood, which means something like engaging in violence that causes there to be blood result. And you sort of wonder whether or not that example is just sort of a kind of over-literalism that they had about language. And so when they talk about equitable exemptions, it's really just a reaction to over-literalism. So maybe it is, maybe it isn't. Who knows what the language was like at that time, whether they understood drew blood in the same way. But that example always brings that to mind to me.
So I wanted to talk about the same example, whoever drew blood. Aristotle has this example of anybody who strikes someone with an iron, and imagine somebody who's got an iron ring, and he shouldn't be subject to some sentencing enhancement just because he hits somebody with happens to hit somebody with an iron ring. The linguists talk about tacit quantifier domain restriction. So, classic example: I open the fridge, I say, "There's no beer," and my 13-year-old or my 10-year-old, he would be the one who said this, like, "Oh, Daddy, there's no beer, anywhere." Like, no. You could see. Everybody acknowledges this phenomenon, but then one reaction is, you have tacit quantifier domain restriction all over the place. One interpretation is people say things that are false almost all the time. Almost everything we say is literally false, but it's not a problem because of reason. And I hate that reaction. I say, like, no, we've got to interpret people charitably to be saying true things. They're implicitly, tacitly, in context, restricting their scope. So just as David wants to interpret these judges, not to be lying, right? We want to, say what they're saying to be true. I think we want to interpret them as literally saying, we are interpreting. Maybe interpreting the law instead of the legislature, but genuinely saying something that's true instead of taking something and just taking a meat cleaver to it. So it's always struck me that the equity of the statute and the tacit quantifier domain restriction are the same basic phenomenon. And Aristotle was onto the same stuff that the current linguists are onto. But the debate about how to interpret those, if you go with interpreting human beings as generally saying true things, it's not going to work quite as well for your interpretations.
So maybe another example to point out is the Starr v. Robinson case, which was another early case dealing with equitable interpretation. And there the statute at issue said that all bond or bonds which have been taken by the sheriff are hereby discharged. And so that's, again, a spot where I would say that's broad. It doesn't seem ambiguous, and yet the court read in a limitation or an exemption to that statutory language to say that it didn't apply to particular types of bonds, where it felt that the court decided that it would conflict with certain sorts of property or contract rights. And I guess what I would say to this broader question is it just sort of a reaction to the legislature being too literal or being sloppy? I don't necessarily have a position one way or the other on that, but even if that were the case, I don't know that that's inconsistent still with the type of reasoning that would be relevant in a religious exemption case. Because if you read the People v. Phillips decision, where the court is analyzing the requirement of subpoenas that applies broadly and did not at the time have an exemption that applied to the priest, in some ways you get the same sort of feel from the judges there, that this seems overly literal. We can't imagine that there's a really good reason to subpoena this guy, and so we're just going to carve it back. And I think that same sort of reasoning is not inconsistent with ways in which we could imagine courts providing religious exemptions today. And just sort of as a separate point, as an originalist matter, one thing that is interesting to me is that the historical evidence we have for religious exemptions is some ways, I think, more robust than the types of historical evidence we have for as-applied challenges for speech, for example. I mean, the first and a really robust decision that we have that is still fairly early in our republic is providing a religious exemption. And we don't have anything quite as clear-cut like that in the freedom of speech context that I'm aware of. And yet we provide more robust ability to have as-applied challenges in that First Amendment context. And so part of what I think is interesting too is why are we requiring such a heightened level of historical evidence or justification for the religious exercise context? Why is Justice Scalia and why are other scholars sort of determined that that's necessary in a way that we don't elsewhere for other sorts of constitutional rights? And if that's a double standard, is it justified? Those are some of the questions that I'm exploring. But thank you for those comments. That's all very, very helpful.